Good morning, everyone. Hello to the DICE Alliance webinar on June 30, from Regulation to Realization, Navigating the EU AI Act Together. While we are still waiting for a few people to join, maybe I can quickly introduce the webinar program today. So I will start with a brief overview of the DICE Alliance, introduce the 4 participating projects. Then we will start at the top level. What is the AI Act and why is it important to consider AI ethics? Then we will move to the company level to examine what this implies for businesses. Next step will be to consider companies and their role as data owners, where data sovereignty, governance, and interoperability are key to the success of AI. And we will continue then with the work that is done within the projects, with frameworks, tools, methodologies from the projects involved in DICE. So, what is the DICE Alliance? The DICE Alliance is a cluster of 4 like-minded projects. On the left, so let's start here in alphabetical order. On the left is Achilles, that stands for Human-Centered Machine Learning, lighter, clearer, safer. So we all know AI models are incredibly powerful, but they have 3 weaknesses. They need huge amounts of computing power, so they are not exactly light. They are often hard to understand, so not very clear. And sometimes they react in unexpected and inappropriate ways, so not fully safe. Achilles tackles exactly these 3 points. The project develops techniques, metrics, and tools to make AI systems more efficient, easier to understand, and more trustworthy. Then the next one is Accomplish. Accomplish has an even longer name. Accomplish stands for Automated Assessment and Certification, Compliance of Organizations, Systems, Data, and AI Operations in a Human Understandable Context. So, what an acronym. While Achilles focuses on the technical side of AI, Accomplish asks a different question. How can companies actually prove that their data and AI systems comply with regulations, and ideally do this automatically? To answer that, Accomplish is building several tools: a compliance digital passport, a toolkit for data and AI operations, and an integrated compliance platform. The next one is Certain. Certain stands for Certification for Ethical and Regulatory Transparency in Artificial Intelligence. Certain focuses on companies that build and operate their own AI system. For them, regulations need to be translated into concrete testing and certification procedures. That's why Certain develops tools and procedures that help companies prove and certify that their AI systems meet European requirements for transparency, trustworthiness, fairness, and data protection. And finally, on the right, Data Pact. Data Pact is also an acronym that stands for Compliance by Design of Data and AI Operations and Pipelines. So the word is a bit mixed. And the idea behind Data Pact is very simple. So instead of checking legal, ethical, and sustainability requirements after a system has already been built, why not build compliance in from the start? That's exactly what Data Pact does. So integrating these requirements directly into the development of data and AI pipelines. The project provides tools, toolboxes, and frameworks that helps organizations stay compliant, reduce bias, ensure fairness, and support more sustainable AI practices. So to sum up and to explain why we are working together in the DICE Alliance, Achilles, Accomplish, Certain, and DataPact are all laying the groundwork for a trustworthy European and AI and data economy. So AI shouldn't just work technically, it also needs to be transparent, secure, ethically appropriate, compliant, and sustainable. Achilles improves the properties of AI itself, while Accomplish, Certain, and DataPact develop the methods, tools, and evidence needed. So this as a first basic overview. Now we have the speakers from each project, and if they feel like I missed some details in the description of the project, they are free to add. Of course, they will present what their project is doing. But we will start, let's say, at a top level. So, Yazaman, you are from DexI. You're a researcher in AI ethics. So you will present the AI Act, but also the importance of AI ethics. So may I hand over to you so that you can now continue with your presentation.
Perfect. I hope you can already see my screen.
Yes, we can see your screen, and now it's in presentation mode.
Amazing. Okay, so hi everyone, and thank you for creating this, let's say, opportunity to chat, and I'm happy to be here. So I'm Yasaman Yousefi, and I'm a researcher at DexI. We're a group of researchers working on AI ethics and AI compliance, coming from different fields of studies. I'm also a researcher in the Department of Legal Studies at the University of Bologna, where I work on similar topics. In Certain, we are basically a partner as DexI. So my presentation will be about AI ethics and AI Act. I have to unfortunately keep it very short because of the time limits, but I'll try to cover as much as I can in the 10 minutes slot. Okay, so first of all, just a quick distinction that needs to be made is that AI ethics is not the same as AI compliance, and it is not necessarily related to AI regulation. So it's a standalone field of study. It's a standalone discipline, and it is so much alive. So many people think that after the AI Act has come to play, ethics is like kind of dead or like transferred into the AI Act, but that is not a correct statement. So what are some of the fundamental problems that AI ethics identify or have identified? The first and kind of the most important thing that academic research in this field started on is algorithmic bias. I also did a doctoral thesis on that. So this is basically about AI or machine learning algorithms that tend to replicate existing issues related to bias or discrimination in our societies. So they tend to mirror them, replicate them, and sometimes even make them more intense, intensify them. The law that exists, at least at the European level, protects us against discrimination. But in this case, in the case of AI discrimination, we have to kind of look at it differently because in most cases, discrimination happens in an indirect way, and it is not as easy to take it in front of a court of law as traditional cases. So traditional discrimination criteria cannot simply apply to AI discrimination. And then we have something called intersectional discrimination that basically is not addressed in the law. So that's a shortcoming of the law. So like, for example, let's say a person that is a Black Muslim woman is discriminated against. So this person has several protected characteristics. And as a result of all of them, she's facing some discrimination, but the law does not know how to exactly protect that person. Okay, this is problem number one addressed by AI ethics. Then problem number two would be algorithmic transparency. So knowing the inner logic of algorithms. or as you may have heard of it, the black box issue. That of course basically um, creates the issue of not knowing how algorithms make a decision that they do. The third problem would be loss of human control. So we have with AI we have automated or semi-automated decision making also in critical maybe sectors and high risk sectors, and we need human oversight. So there is a necessity of a meaningful human control at every step of decision making. And we need to clarify the accountability mechanisms and the liability issues and so on and so forth. And this is, again, one of the fundamental problems that AI ethics addressed before the AI Act was even a thing. So we have also some collateral issues, of course, like privacy, data protection, legal personhood for AI systems, intellectual property, competition, predictive justice, and all of these have also been addressed by AI ethics before becoming, let's say, part of the regulation that is now regulating AI. So what was the roadmap to the AI Act or to the regulation that we have today? First of all, we started with several academic research. We started to understand those ethical concerns that I was mentioning and to develop early sets of some principles. Then there were some multi-stakeholder fora from 2017 to 2019 with a wider discussion with academia, industry, institutions, NGOs, universities, and we started adapting sets of principles based on the academic research that made the basis. Then there were some institutional debates from 2018 to 2020. So the EU and member states started adopting AI charters. They started working on the white paper and so on and so forth. And the conversation from there became the conversation about regulation that started from 2020 to now. And basically in 2024, we had the AI Act come out. So it's a very long process, but they come in a chain, hand in hand. So basically, the principles that we discussed earlier started to inspire rules and started to become regulatory approaches and being pushed at the EU level. One important aspect of this chain was the EU Commission High-Level Expert Group. So the High-Level Expert Group was set up by the Commission in 2018. It had 52 experts. It highlighted 4 principles, you can see them in yellow, and 7 key requirements. And it started, let's say, towards the most trust-oriented approach. So it identified prevention of harm, respect for human autonomy, explicability, and fairness to build this framework for trustworthy AI. And what happened in 2022 is that there was a white paper on artificial intelligence by the Commission that took those 7 core principles and turned them into a risk-based approach. So it started focusing on human oversight, technical robustness, data governance, all of the keywords that now we hear a lot about. They started being talked about after the 2018 high-level expert group and the 2020 white paper. And there was a lot of talk on transparency, on diversity, fairness, and on here we also started adding societal and environmental well-being and accountability to the discussion. In 2021, the EU started this its approach to AI regulation. So it started the Commission welcomed initiatives that were building on we're trying to build trust in AI. You can see some examples here. Then the Commission said that they will propose a regulatory proposal in 2021, and it happened, but basically it came in 2024 because of all of the bureaucratic things behind. So came the AI Act in 2024, and what happened is that basically we took on a risk-based approach, and we did not really add any new rights. So, for example, in the issue of discrimination, there is really no individual new rights identified. But we started to introduce mechanisms for compliance, like self-assessed compliance and documentation mechanisms and all of that. And I would say like the most innovative part of the AI Act in comparison with what we had before is that it first of all wants to lay down harmonized rules on artificial intelligence and amending regulations. And the goal is to kind of have a Brussels effect, even though some people say it's not doable. The goal is to have a Brussels effect and have it kind of like be the new GDPR. GDPR will stay for data, and the AI Act will stay for AI systems. And let's say the most innovative element of the AI Act is the risk-based classification of AI systems. So we have like a pyramid. Well, we used to have one pyramid, now we have two pyramids. So the thing that you see on the left is basically the classic risk classification. So we have from lower AI systems that just need some transparency mechanisms to comply to limited risk AI systems. Then we have high risk AI systems. These are usually systems applied in high risk sectors, for example, let's say in healthcare. And then we have prohibited or banned AI systems that, let's say, for example, systems used for manipulation or social scoring, and so on and so forth. So this is like the risk tiers of the AI Act. And then came the general purpose AI talks. So we have general purpose AI that kind of pose different risks than the high risk AI. And then there's like overlap if they are also high risk AI. So it's basically general purpose AI systems are basically capable of doing more things than a traditional AI system, let's say. So they have a general purpose, they do not have one specific purpose. And some of these systems could actually pose systemic risks. And those systemic risks are another tier of the risk introduced in the AI Act. And basically, all of these come with a mechanism of compliance that now our other colleagues will for sure delve into. But basically, I don't know if I can take questions right now.
Yeah, maybe we
Probably.
can ask questions afterwards, or we
Yeah.
can take them for the Q&A part at the end. So maybe
Yeah, sorry about that.
everyone write down your question and ask them at the end.
Okay, thank you. And yeah, so basically, we also have other mechanisms coming in play. So we have, for example, the code of practice for general purpose AI, that is like a voluntary piece of how would you call it? It's not a regulation because it does not regulate you, but you can voluntarily adhere to it in order to show your compliance. Then we have the standards that we're waiting for in different clusters. We have, so standards would be a mechanism to kind of understand our compliance again and demonstrate it with the AI Act. We have sector-specific regulations for high-risk sectors. For example, let's say the medical device regulation in the medical field. So you have to comply with both the AI Act and the MDR if you have a healthcare AI system, and so on and so forth. So I will just stay on topics of AI ethics and will not get so much into AI Act because I'm sure colleagues will.
Yasaman, may I ask you, is this your last
Yes.
slide? Very
Yes.
good.
Yeah, sorry, I went a bit overboard. I even practiced for 10 minutes, but it's really tricky. Okay, so why do we think AI ethics remains essential today? Because, in my opinion, regulations ask, is this legal? Do we need to pay fines if we don't comply? Uh, while AI ethics asks, is this ethical? Is it necessary? Is it proportionate? So we make duties more meaningful in real settings. And we start like to build trust beyond compliance and box ticking checklists and stuff. And I think in the long term, it also really is the way to go for reputation of companies. So it's not a substitute for law, we know it, but it's a scientific and practical method to identify, evaluate, and mitigate AI harms. Thank you so much for listening.
Thank you, Yasaman. So that was really a comprehensive overview of both the AI Act and AI ethics, but not to lose too much time. So Florian is already visible here. Open his camera, and Florian is a policy officer at European Digital SME Alliance, and he is representing the Accomplish project. But he will, of course, explain why it is not only, let's say, a negative implication for companies, but also, let's say, a positive opportunity for organizations. Please, Florian, the floor is yours.
Thank you. Exactly. Hello, good morning, everyone. My name is Florian Schuck. I work as a policy officer at the European Digital SME Alliance. We are an association representing IT SMEs on the European level, active in 30 European countries. And Digital SME is one of the partners in Accomplish, which is also an EU project working to develop an AI-based platform for compliance. Accomplish is basically creating a platform that will help companies with the AI Act, Data Governance Act, and the GDPR primarily. And it will be based on an LLM-powered interface so that companies can understand in plain language their own compliance posture, where their gaps are, and what corrective actions can be taken. At the moment, Accomplish is working on the alpha release of the platform, which should be launched in September, when it will be deployed in 4 demonstrator hubs in the energy, automotive, aviation, and in the robotics/manufacturing sectors. For more information, I think in the slides, there will be the link to the website of Accomplish as well as to the other projects. But let's dive into the policy implications of the AI Act. After Yasaman very well summarized the main structure of the AI Act and its connections with AI ethics, I will go into what it means for SMEs, which I think many of the listeners today are from SMEs. So it will be interesting to get a bit of an overview of that. Important to say that I cannot give legal compliance advice, of course, but I will just try to read into the Act and see what's important for SMEs to know at this moment. So as Yasaman already explained, the obligations of the AI Act are risk-based, so it depends on which use case your AI system has, how is it used, and it also depends on whether you are a provider or a deployer. So there are different obligations based on your role in the value chain. And I would say most cases, if you are not belonging to one of the high risk or unacceptable sectors, then you will be classified as minimal risk. There are no extra rules, but it is really important to check whether you are and your AI system is in one of the higher risk tiers. So I will first give you an overview of what applies now in this year, because the applications enter into force gradually over time. So since February 2025, we already have a few obligations into force, such as the prohibited uses, such as social scoring, emotional or vulnerability manipulation, remote face recognition, which is untargeted, and some other things, with some exceptions for law enforcement. And on the same date, also into force entered the obligations for companies to take measures to ensure their staff's AI literacy. Of course, this is a topic all on its own, which measures are appropriate, but at least that is what the AI Act says for now. From the 2nd of August of this year, AI companies will have to label AI chatbots, disclose AI-generated videos like deepfakes, and mark AI company content, for example, on social media. And this at least applies for those AI systems that come onto the market after this or from this date. Those that are on the market already will have another 4 months to comply. And this is new, but from December this year, also so-called AI nudifiers will be banned. So they will be part of the prohibited uses of unacceptable risk. So AI systems like on X that can show your intimate parts or create child sexual abuse material. When you want to comply with the AI Act, it also is really important to treat it together with the laws that intersect with it. So where this is most relevant is the data framework of the EU. So even in the AI Act itself, in Article 10, it reads that if your AI system is high risk, then it needs to be trained with relevant, representative, error-free data. And I think trusted data spaces, maybe that some of us are working on here, are exactly built for that purpose. When you train your AI model or system, of course, if you want to use personal data because you, for example, want to prevent bias in it, as Yasaman just said, there are some boundaries for that. We all know the GDPR, it protects personal data, and it sets some boundaries for which personal data can be used and in what circumstances for AI training. Important is that there is a legitimate interest for the company to use this personal data, and that individuals cannot be identified after the training based on the data that was used. And then, of course, if you have a connected product, then you are protected by the Data Act, because it allows you to access the data and share the data that the connected product generates, and to use it in the training of your AI model. What the AI also has is a lot of specific provisions to make life and compliance easier for SMEs. So for instance, there are regulatory sandboxes available already in some countries, but not in all, where you can enter your AI system or your solution with an AI component and test it out if it complies with the current legislation. I would recommend checking with your national authorities about this. Also for the documentation, for transparency, for example, or for reporting, there is simplified ways and templates for SMEs and micro enterprises. Also the fees and the fines for conformity assessments and for penalties are lower for SMEs and startups. There's dedicated guidance and help desks available from the European Commission, especially for SMEs, and various tools to check for free and self-assess whether you are already compliant. Now we need to talk also about the AI Omnibus. The AI Omnibus is a simplification tool that the Commission decided should be simplifying the rules that the AI Act has, after we realized that the competitiveness of Europe is in danger, and we need to be fast and give companies more time to comply with these very strict rules. It was approved by the European Parliament and the Council this month, and will be formally adopted next month in July. I already mentioned the transparency duties and the notifier ban later this year. But the main reason for the rush of the AI Omnibus is that the high-risk products obligations would have been also entering into force on the 2nd of August of this year. But due to the AI Omnibus, they have been postponed, and it depends on whether your AI model is standalone. Then you need to be compliant on the 2nd of December 2027. Or if the AI is embedded into a product that is already covered by another regulation with the conformity assessment, then you will need to be compliant by the 2nd of August 2028. Further changes are that the SME reliefs that we see in the previous slide were extended to a small mid-cap category. So where SMEs are supposed to have less than 250 employees and less than 50 million revenue per year. Small mid-caps are those companies with fewer than 750 employees and fewer than 150 million in turnover every year. So what I would recommend for any SME that wants to comply is to look now what your position is, whether you're a provider or a deployer. There are different rules and guidances available for how much fine-tuning counts as making you a provider of an AI model. So be aware of that. And also, of course, which risk tier your use case falls into. Then I would recommend meeting now this 2026 baselines for the transparency duties if you are a provider, and later this year also for the additional prohibitions, and then prepare for the high risk obligations coming into force in the next and the one after that. And as I said before, it's also important to not only treat AI and data compliance as separate silos, but to really make sure that when you comply with GDPR, for example, you integrate also your AI compliance into that pipeline. And here I also added some links to some helpful resources, especially the AI Act Service Desk, which was especially established for SMEs. Also Digital SME, my organization, has an AI Act conformity tool as a free self-assessment, and a few others which you will able to explore in the presentation. I think this is it from me. If you have any questions, don't hesitate to reach out, send me an email, but I'm also looking forward to the Q&A later in the session. Thank you.
Yeah, thank you, Florian. So you just mentioned Q&A. Yasaman, maybe you could take a look at the Q&A part of this webinar. Matteo Agati asked a question which might be relevant for you, so maybe you could take a look at it and try to answer it. Florian, so you said high-risk AI systems need trust. And this is where Anil can continue now. Anil, please come to the stage.
Sure.
Sorry, I don't see the Q&A part.
Well, then I will copy the question and put it into the chat, and then you can see it.
Thank you so much. Yeah.
Anil, so we lost a little time, so maybe you could keep your presentation short. And as I know you are able to present your presentation quick and crispy.
Yes, I'm known to be a fast speaker. So hello, everyone. I'm from IDC here. Today I would like to tell about how data spaces enable the trustworthiness in AI. So we all know that AI agents now can now act on our behalf. So the AI agents are replacing humans in the data sharing operations and can now act on our behalf, whether we are a person or an organization. So they can plan, negotiate, and transact at machine speed. And so this needs to be taken seriously because there are some risks that come along and that are also highlighted in the AI Act. The first problem would be that an agent has no identity and no mandate and no accountability of its own. So the EU AI Act is asking for exactly for that, and the transparency, accountability, and traceability should be taken seriously. And but here comes the trust, and actually this can be something. The trust and trustworthiness are values that can be established very easily by the data spaces, and especially thinking from the current state of the art of the technology. The real bottleneck then would be for the enterprise AI. And by the way, I wrote here enterprise AI, but personal AI use is also not so different. Like this is also a dimension where you need trust. The real issue is trust. And for this, we are taking so we just want to talk about the two sides of the coin. So the data spaces for AI and AI for data spaces, like which one is providing what to the other. So the data spaces are that missing trust layer, and it's working in both directions. So for example, for AI, data spaces provide sovereign access to quality data from known providers and with clear rules and what an agent may use and for what purpose, and at what price and in which context, and plus offers some provenance and full audit trail tools that is called as observability, for example. And what AI gives for data spaces is it's automating the show parts and discovering the negotiation and mapping what data is available and how it can be shared at machine speed. So I want to underline that word, machine speed, because it requires protocols to come in place. There is really no need or any further discovery on that end at the moment. So from the technical part, at least from the technical interoperability part, we know that a lot of technologies already exist. Here, I apologize that I didn't write the explanation of these abbreviations here, but I will tell them in detail. First, it starts with identity. So so every agent acting under a decentralized identity is tied to its organization. Then comes in the trust part, where we call it DCP, the Decentralized Claims Protocol, which is a protocol that will become an ISO standard soon, has its number and process already in place. And then access comes in, which is provided by the database protocol, which is again under ISO. And so these are providing the steps that agents can act on behalf of the humans at machine speed, so that they can do things according to the rules that are set before everything. And in the execution part, of course, we have the MCP, which is the Model Context Protocol offered by Anthropic at the moment, and there may be some other examples that will come in the future, but this is the one that allows, as you know, the AI to communicate with the external system. So every step is governed and should be governed by protocols and by machine-readable stuff, and they should be tied to an attributable identity, which is very important and which is detailed in a section in IDSA rulebook as well. So in the rulebook, there are two approaches here. The data space first, which is talking about how the agent works inside the data space on behalf of its organization, which is already a member of that data space, and the agent executes pre-negotiated contracts with an issued token. And the agent first approach is the agent finds data that it cannot yet access and negotiates on the fly using data space protocols and the other protocols. So it's granting the permission to share data dynamically. So in both ways, access follows a negotiated contract and an attributable identity, which is fulfilling the values that are sought by the EU Data AI Act. So turning it into practice, so it is the thing that we all need to do together. So these mechanisms are really mapping very well to the EU AI Act, to the terms under it, like transparency, traceability, accountability, data governance, and human oversight. And with the existing technologies, this can be done, and there is always a room for improvement, of course. And on the other hand, we are also in IDSA working with, so we established a task force on data spaces and AI, and in a couple of days, we will have our first position paper that will be published, which is talking about this issue. And also highlighting how the rest of the world is tackling all these issues and what kind of examples are available. And one important thing for the future that I want to highlight, and then I will conclude my presentation, is that the governance of the data is not only the issue at the moment, but for the future, the focus should be on how AI decisions are produced and how sovereignty over the AI decisions is super important. And there is also huge room for improvement on that end. And that part should be worked in higher efforts in the future. And then I can conclude my presentation, and back to you, Andreas.
Thank you, Anil. So I think in the future we will hear a lot about data spaces as key enablers for trustworthy AI. Now we have Veronica Campbell here from the Malta IT Law Association, and she will present the Data Pact Compliance Framework. And I still see the question from Matteo here that I've put in the chat. So what is the best way to demonstrate compliance with the EU AI Act? Maybe, Veronica, the compliance framework is also part of the answer. So, Veronica, please, stage is yours.
Thank you very much. Good morning, everyone. I apologize if my voice gives out a bit. I'm very sick this morning, unfortunately, but I'm going to do my best. As Andreas said, I form part of the Malta IT Law Association, MITLA, which is one of the partners within the Data Pact project. So today I'll be walking you through the Data Pact AI compliance framework. So essentially what it is, what it covers, and what it offers to organizations that work with data and AI. A brief introduction of the project itself. The mission of the project is embedding compliance and sustainability into data and AI operations. The project spans 7 real-world use cases across a number of sectors.
May I interrupt you, Veronica? Maybe
Yes.
you already moved to the second slide, but we can still see the edit mode of the presentation.
I don't understand.
Yeah, maybe you should move to the presentation mode, and we can see here the edit mode of the presentation.
I should be on presentation mode.
Maybe you have to switch the screen, but yeah.
So I'm on slideshow at the moment.
Yeah, we can not see the shared slide. Anyway, so
perhaps I should stop and start again, stop sharing and start again.
Well,
I'm not sure. Oh.
And then select the screen where the slide is shown, where the presentation mode is switched on. Yeah, there it is. Very good.
Okay, is it fine now?
Yeah, it's fine.
Okay, so I'm on the second slide. So as I was saying, the project spans 7 real-world use cases across a number of sectors. So we have law enforcement, smart cities, healthcare, media and entertainment, and also customer relationship. And the project brings together a total of 35 tools across 6 integrated collections. Moving into the compliance framework itself, this is at the heart of our project, and it is a modular resource that combines legal, ethical, and social impact guidance. This is a living resource, so we're constantly updating and expanding the contents throughout the lifetime of the project itself, to make sure that, first of all, we're updated from a legal standpoint with new guidance, possibly case law, and any updates to the legislation itself, and to also make sure that it remains relevant to our use case partners. From a legal standpoint, we cover 4 cornerstone EU regulations that govern AI and data. And these are the GDPR, the Data Governance Act, the Data Act, and the AI Act. So as I'm sure we're all familiar, the GDPR governs personal data, and the Data Governance Act enables trusted data sharing. The Data Act regulates data flows into AI pipelines. And then we have the AI Act, which is obviously the core compliance target for AI systems. So the Data Pact framework addresses how these legislations also interact. With respect to legal artifacts, so the legal layer of the framework is delivered through 3 types of artifacts. So first we have the primary regulatory sources. So this is obviously the text of the law itself, official guidance, such as, for example, official guidance by the European Data Protection Board when it comes to GDPR, for instance, and also case law of the Court of Justice. Then from a secondary level, we also have carried out in-depth legal analyses of each of the 4 laws. So this further supplements with further commentary on and interpretation, let's say, on the official sources. And finally, we're also developing assistive artifacts. So we have decision trees. We've already completed a flowchart with respect to the GDPR. We also have Q&A data sets for each of the 4 laws, and also LLM guidance. So this is the legal layer of the framework. And then we come to the ethical and social impact framework. So beyond just legal compliance, the framework also includes this unified methodology for ethical and social impact assessment. So this covers ethical risks, social impact, human rights, and environmental considerations in one single approach. This is designed to be accessible to non-technical users, so to be usable by people that don't have necessarily a technical background. And it's structured around 11 risk categories, as we're seeing here. So we have bias and fairness, environmental impact, agentic risks, explainability, privacy and confidentiality, security and misuse, governance, human in the loop, reliability and manipulation, human autonomy, and finally, transparency. So what does the framework actually offer? To summarize, first of all, we have comprehensive coverage, regulatory coverage of all 4 EU legal instruments in one place. So we have a single framework that covers the GDPR, the Data Act, the Data Governance Act, and the AI Act, with specific guidance on how these laws also interact between them. Second, we have an integrated approach. So here we cover both legal and ethical, and we also have a practical approach that spans the whole AI lifecycle. And finally, as I mentioned before, this is a living resource, so it is updated every 6 months to account for any changes in legislation, and it's also validated through 7 real-world use cases. That should be it from my end.
Thank you, Veronica. Yeah, so that was the compliance framework, and DataPact. DataPact also offers, let's say, a solution on the practical level, on the technical level, and this is now why we have Stefano Bonafieri here from the University of Southampton. Not to lose too much time, so as the time is running, Stefano, please keep
Hello.
it.
Hi, everyone. This is going to be an odd one. So far, we had a lot of things that are done or can be done mostly on paper. Now we go and see what we can do on technical support. I'm Stefano Bonafieri from the University of Southampton, and I'm the technical coordinator of the DataPact project. What DataPact does, partly has been already said by Veronica. The idea is that we need to consider all the aspects of an AI lifecycle to understand how we can be compliant. And so you need to look deep in each of these in different way, and you need to have tools to try to address what you need in that specific case and part of the AI lifecycle. We want to support compliance by design, so there are lots of tools that are about data management, data manipulation, because all of these things can introduce aspects which needs to be considered when you want to be compliant. DataPact has several use cases, as you can see. So if we go down, what is a DataPact solution? It's basically a composition of 6 collections of similar, or anyway, of tools that address similar aspects. And each of them are try to work together as much as possible, but can also work in isolation. I mean, this is true at tool level and also at collection level. And we want to support the end users, also giving an integrated access to all of this, but without being prescriptive. So the users have also the possibility of using the tools as they want. In practical terms, we have 7 tools for the SSR, 6 for the policy R. You can read what they are about if the term is not self-explanatory in itself. We have 6 for Trust R, 5 for Pipeline R. As you can see, Pipeline R and Apply R are very technical tools because Pipeline R is about managing the actual data pipeline, so including aspects there that can be that are important and relevant for the compliance. An example is the SSR. We have seen the presentation of legal and social technical, but in there you also have something about advisory compliance, so you can browse the legislation and see and ask questions. You can process, you can submit your process and get some feedback with LexAlign, which tells you if you are already compliant or not compliant. So it is based on pipelines, on processes. You have some support for DPAA, and also the project provides you with a comprehensive reporting of what's happened in your system. So you can you are suggested if you are compliant or not, but also you can check yourself and then take the actions you need. We have a catalog. That's the URL. I can put it in the chat later if you want. And this is the do-it-yourself way. So the tools are there, are accessible. 90% of them is open source, and you can download them, use them the way you like. It's a do-it-yourself way. So we really don't want to be prescriptive. But also we can support the end users, and we support that through a portal. This is the structure of a portal. Basically, you have some security, a reverse proxy. You have a UI, but also Keycloak, which gives you authentication. And then you have the tools, and then you have a mini storage. We don't provide large storage. Each tools offer the storage as they want. What we are working on is what we call scenarios. Basically, as you can see in this picture, which has been presented to our review, a scenario is a set of steps that a user needs to take when he wants to check if he's compliant or not. And they are very different level, very different subject to the tool, and they need to be put one after the other. There is each of these scenario, it's sometimes repeated across. So there is a concept of template, but eventually each scenario is different and specific to the case you are considering. So what we are doing, we are trying to work with this concept of scenario to help the user while still granting him the freedom he needs to create and be supported in what he needs to achieve. This is a sneak peek of the portal, which is still under development, has been now currently deployed in several use cases, and we are working on that. I've been very quick, so I know that this is appreciated, but happy to answer any question that you might have on these points. I'll put the links in the chat for you to use them.
Thank you, Stefano. So maybe you provided already an answer. So the question from Matteo is some kind of a guiding question. So what can be done to demonstrate compliance with the EU Act, AI Act, and you provided with the solution from Data Pact already an answer. So last presenter today is Isabelle Landreau from IDEMIA. Isabelle, are you still with us?
Yes, exactly. I'm here. Can you hear me? Yes. Thank you so much for being with us this morning. So I will be very quick because I think this is more important to have to respond to the questions. So can we go to the presentation, and so
there it is.
Yes, exactly. Can you switch on the term? Okay, exactly. So I would like just to be quick on CETA and to tell you the advantages of this EU project. We have theoretical and practical advantages. So the theoretical advantages are mainly, can you change the slides, please? So it's encompass many different data regulation. So not only the AI Act, but also the GDPR, but also, you know, the Data Act, the Data Governance Act, the DSA, and the DMA. So that's really one important advantage. And also this certain project gives you, I can't see the slides, but it's okay. Next slide, please. Then also, it gives you a list of obligation by mapping the relevant obligations. So this is very important, and you can use that in your own industry. Okay, so not only it's integrative, it gives all the an overview of all the data regulation, but it gives you the main obligations. So that's the first step. And the second step for practical advantages is you can use directly the documents we have under certain, which is, for example, you know, the model form we have. Can you change the slides, please? Yeah, the practical advantages, exactly. So I would like to be quick. Yes. Next slide. Yes, exactly. So as everybody said, risk approach, that's really interesting. So the idea is we have not only an overview of the AI, but all the data act, okay? And so the idea is that we need to create bridges, and certain does that, okay? So it means that if you're compliant with the AI, okay, then you will be able to be compliant with all the data documents, all the data regulation, and you can use the tools from certain. And also the idea is that you have the entire view of the data chain, which is very important. Okay, so not only data providers and data deployers, but also data holders. Okay, so I insist on that, which is really interesting because you have the entire chain of the data value. And then you can really use the key compliance method in your entity. I don't know if you check that, but I advise you to go and check. This is really a very practical tool, and you have the analysis of your tool with the AI, and it encompasses everything. So not only the data protection, but also the ethics, but also the green data. So it's really a good tool. So please click on the link to use this key compliance method. And also they use, and I recommend to use the ETSI standard. So because we have a variety of, you know, data regulation, this is very important to be able to have standards. And I insist, we need to have standards. And in any case, in any industry, okay? So if we do not have harmonized standards inside Europe, as we say, it will be a lasagna, you know, it will be the lasagna effect. So to avoid that, we need to have harmonized standards, and you can use for the beginning the ETSI standard. So I have questions to the audience. We need also to create standards per sector activity because we are in the biometry sector and it's very specific, you know. So we need to have standards for our sector. And also I encourage the regulators to create a similar NIST institution, but for Europe. So it means that we need to be able at the European level to certify our, you know, AI systems and AI tools. That will be key for us. Okay. So I'm available for your questions. I've been very quick. I'm sorry, but we need to have time for questions.
So thank you, Isabel. So that was just on the point. So we have now 11 a.m. 1 hour is over. So we have listened to really comprehensive presentations. We could have filled 2 hours with all these presentations. And it is an important topic. So next time we will really have more time for such comprehensive collection of presentations. So those who still like to answer questions and still like to stay with us for more minutes, feel free to raise your hand and speak up. So now I can really enable all the presenters to speak. Just you should be able to raise your hand. So Yazaman, so you already raised your hand?
Yes, I was thinking maybe I quickly also give my 2 cents on the question that was asked of me. Even though I think the other presenters actually covered it up to a certain point,
Exactly.
but just to maybe quickly also say that there are some tools that already exist for compliance checking. For example, there's the EU AI Act compliance checker. There are some guidelines by the Commission, for example, the guidelines on high-risk classification. There are some checklists, for example, the Altai checklist for trustworthy AI self-assessment, ALTAI. And basically you can do kind of a self-assessment for your project with one of these tools, or a combination of these tools. You can draw a compliance plan that includes both the AI Act and AI ethics. So you can demonstrate compliance through that. So you start from the development, from the design phase of the system, and then you basically map the different project objectives, let's say, to different risk tiers of so your AI. Basically, you just classify the risk of that system and the objectives of that system. You look into them, you look at the purpose, and you kind of map them to see how your system, where it stands in the risk tiers. You have to focus on the different AI Act obligations in case, for example, you fall under the high risk system tier. And then, of course, if it's a sector specific AI, so if you have to also comply with Annex 3 regulations that are, for example, MDR, the robotics, and so on and so forth. So let's say you have AI system that is applied in healthcare sector, and you have to comply both with the AI Act and with the MDR. So there you have to look at different tools. Also for compliance with the MDR, you have to document everything. You have to define all of the elements, for example, of human oversight, transparency, all of these elements of your governance. You have to define them yourself. So it's convenient to kind of from the beginning, from the go, come up with an AI Act and AI ethics compliance plan, and write everything maybe in a deliverable. I hope that answers it.
Yeah, thank you, Yazaman, for this question, no, for this answer and this, let's say, explanation. And Matteo says here, thank you. So he's satisfied with your answer. Quick look at Tiziana's question that Stefano already answered. The question was, are the data pack project tools applicable to organizations that are multinationals? Yeah, so here we are talking about European funded projects, but nevertheless, so multinational corporates who want to act on the European market, let's say, should use such tools. So, yeah.
If I can say something about these available tools and checklists, they are very useful, but there are two drawbacks to that. First, it's a ticking the box, so you're not always able to understand the knock-on effects of things. Second, they are very high level, very generic, so sometimes it's not easy to understand if something applies or not to a technical tool. And third, they don't tell you what you should be doing to change the situation. So I'm not suggesting the data pact is the solution for all these things, but I'm saying that when you think to the problem, it's not just the checklist in itself, because you need to understand the next level down. Does it really apply? What is the technical implication of what's happening, and how can I mitigate the risk? How can I solve the things? And this is what DataPact is trying to do. So also other projects. So I'm just trying to say, checklist in itself is not enough. That's the message.
Yeah.
And I think it's as I'm a technical person, I'm an engineer, and I talk a lot with lawyers. Sometimes the lawyers don't see this problem. Just they say, oh, you have the checklist, you answer the question, you are done. Yeah, but what if you don't know how to answer the question? That's the point. I finished.
Yeah, thank you, Stefano. Yazaman, quick comment, and then we have a question from Jingdong.
Agreed 100% with Stefano, but please do pay attention that under the AI Act, actually research projects are an exception. They do not really need to comply unless they go to market. So what I was saying was to basically start preparing themselves in case they want to go to market later, which would be useful to use these high-level checklists anyways. But of course, once you're in market, definitely take the word of Stefano.
Yeah, thank you. Yazaman, and I would like to conclude with the last question from Jingdong. This could also be answered by Anil, who is also involved in DataPact. Would the DataPact pools be adopted in any data space project?
Stefano, please.
No, it's just saying that we have a use case which is led by Gate, the Bulgarian, and they are responsible for the data space. So yes, we are testing it already in a real existing and running use case. Data space.
Yeah, and the cases in which Gate is involved are also high-risk cases in their urban environment of Sofia. So very interesting to see these use cases. So we already have 11:08, so 8 minutes over the time. Thanks to all who are with us today, and thank you for the presenters for the presentations that you have here shown today. I'm very happy about this comprehensive webinar, and I would like to say goodbye. Wish you a wonderful Tuesday. Stay calm and enjoy the summer. Bye-bye.